What have you done to us, Tony K? That's the cry from the left at the announcement that Anthony Kennedy will be stepping down this summer from the U.S. Supreme Court as Associate Justice for some almost 3 decades, where he became known as the swing voter. And the left is enraged because they had a reliable person, at least on the issues that were most important to them, like gay marriage and abortion. Well, gentlemen, I'm Scott Ott. This is Bill Whittle and Stephen Green, and this episode of Right Angle, which is at least nominally for members only, I would like to explore what you think President Trump ought to do as he's thinking through his next appointment. Now, that appointment is supposed to come as we record this, possibly within days, his nomination anyway. And but I don't want to speculate on whether it's going to be that woman or is it going to be that guy or whatever. But I'd really rather focus, guys, on if you were president of the United States, what are you looking for in a court nominee, and how do you approach that process? As we record this, the president has said that he's already interviewed 4 people, and I'm sure those interviews are ongoing and there'll be more of them. But Stephen Green, what has disturbed me lately is all the talk I hear from the right on the radio and elsewhere about how important it is that we appoint a justice who's going to overturn a particular case. In other words, the right is focused on saying we need to find someone who agrees with us on certain issues. Is that the right approach? Should that be what the president's looking for, or would you recommend something else?
Absolutely. They just have the wrong court cases, because when you're picking a Supreme Court justice, really the elevating principle should be that the ends justify the means. Let me give you an example. You want to reason these things backwards. When a judge hears the evidence in a case, a Supreme Court judge, an appeals judge, what they need to do is figure out where they stand on the policy that could be impacted, and then from there reason backwards through the evidence to find some nugget of law or some sort of invisible emanating penumbra to justify the desired conclusion that they had in mind long before this particular case came before them. I'll give you an example in the Janus case that was just decided earlier. I believe it was Elena Kagan who tweeted live that the real shame of the case is that government unions, public sector unions, are going to lose an important source of funding. See, it's not the law that matters, Scott. It's not the intent of the founders or any of those things. It's, does my pet left-wing group get to keep the ability to take money from people who don't want to give them any money? And I think once you recognize this simple element, Scott, that it's all about power and seizing it by any justifiable means, then I think you'll really relax about the Supreme Court picks. Yeah.
Steve, given your description of that process, the fact that you would bring up a case called the Janus case, I think is just perfect. Who is it? Janus, the god who looks both forward and backward at the same time.
Exactly, and that's what you have to do. You have to keep your eye on the prize, Scott, and that's money and power, with the other eye looking backwards at whatever possible justification you could come up with for that.
Well, in other words, it's the two-faced god.
Yes. Well, it's a good thing Anthony Kennedy will no longer be for the next session on the Supreme Court. Otherwise, that kind of satire that you just heard from Stephen Green would, of course, be called into question and possibly found unconstitutional. Bill Whittle, there's been a lot of talk, obviously, of the Roe versus Wade case, and one wonders whether the right grasps onto that to their own detriment as they talk about these nominees, because the Democrats, while they can no longer block President Trump's Supreme Court nominee without help from Republicans like Susan Collins or what's her name, Murkowski in Alaska, the Democrats basically have said that they're going to fight this thing to the death as an election issue. Chris Matthews on MSNBC announced that he was done with the Democratic Party if they didn't block this nomination, whoever it is. They don't even know who
it is.
They don't even know who the nominee is. But,
so they're just gonna,
but by golly,
Mitch
McConnell stood in the way. That's right. Mitch McConnell stood in the way of Merrick Garland, who was Barack Obama's appointee, and so they didn't let that come to a vote before the election. So, Bill, you're conducting this process for the White House, what do you look for in an appointee? Don't you have to take politics into account and say, you know what, it would be better to find somebody that Chuck Schumer and Nancy Pelosi don't hate?
Well, no, that's never the case. You want to find somebody that Chuck Schumer and Nancy Pelosi absolutely despise. You want to find somebody who makes their head come off. But the fact of the matter is, when Scalia died, the appointment was delayed until after the election. So it's sauce for the goose as far as I'm concerned. I mean, I just have a sense of fair play like that. We did not let Obama appoint Scalia's replacement. And we said we need to wait to see the results of the election. They were happy with that because they thought they were going to win. So it's hard for us to argue against that particular nuance. But let's get back to the point of who we're looking for. We need a justice whose commitment is to the rule of law, and that means making sure that everything that comes before them is conforms to the rule of law, adheres to the rule of law, but not somebody who's making new law. That's what the Congress is for. The entire idea of the importance of the Supreme Court justices, as you well know, Scotty, was never intended to be this. The Supreme Court was never intended to be what it is. This country is a republic, and basically in this United States of America, there are 535 people that live in an actual democracy. 435 representatives and 100 senators get to vote on pretty much everything that affects all of us. They live in a democracy. The rest of us send them there to go and do our work for us. But for the last 100 years or so, since the progressive movement started in the end of the 19th century, early 20th century, this country has been governed by 9 people. It has become an oligarchy that has blocked legislation it didn't like, or created essentially new legislation by throwing out legislation and creating rules. Perfect example was this Obamacare nightmare with Chief Justice Roberts, when he basically said, well, I'm not going to block it, but it's not a fee, it's a tax. Well, it was sold as a fee. If it had been sold as a tax, it wouldn't have passed. How do you not throw that law out? So you can see where this thing goes. From a political point of view, it's actually very, very simple. When Scalia died and we replaced him with Gorsuch, that's no net gain for us. That's replacing a conservative champion with another conservative champion. If we're able to replace a swing voter with a conservative, that's a gain for us. And if Ruth Bader Ginsburg manages to lose a fender or something, then you're going to see the left really lose their minds, because then you will have actually done it. So I think they can block appointees for 2 or 3 years. That's what I think they can do, and I think that's what they're going to try to do, because the laws and the rules have nothing to do with them. Obama got to appoint 2 flaming liberals, and I think subpar justices, certainly in Sotomayor and Kagan. And by the way, just to conclude, Scotty, the fact that a Supreme Court justice is tweeting anything, to me, is disqualifying on the grounds of propriety. This is not what the Supreme Court or any kind of justice, a high-level judge. I don't expect a judge in the lower court of Los Angeles to issue tweets about what he or she thought about a case of minor petty larceny. I don't expect that that's the position that a judge should take.
Well, after the show, I am going to go look up that word that you mentioned, propriety. It's not something that I hear on a regular basis, so I'm unfamiliar with its definition. But my frustration, as usual, is with my own people. Like, I expect the other side to be in disagreement constantly with me. I expect them to say things that I consider to be ill-informed or stupid or ridiculous or bound to destroy the country. That's kind of par for the course. It's when my own people say things like, we have to pick a justice that's going to rule in such and such a way on a particular issue. And I just want to stop and go, look, the job of a Supreme Court justice is not to rule on issues. The job of the court is to rule on cases. Cases come before the court. To a certain extent, the court decides what cases are going to come before it. And so, yeah, they do decide what issues they're going to resolve. But ideally, there should never be a swing vote on the Supreme Court. There should never be anybody who's in that position to say, well, you know, this guy's a solid, you always know he's going to vote with this group, and you always know she's going to vote with that group, and this guy is going to flip-flop. And so ultimately, Anthony Kennedy was the Supreme Court.
He's the entire country. He's the whole republic. One man.
He was a dictator in a sense, in that sense. So it's not supposed to be a council of mullahs that tell us what to do. They're supposed to be ruling on cases that exceed the bounds of any particular state. And so when they make those decisions, they have a couple of things that they need to do. First, they take the facts of the case, and in most cases, they're reviewing previous findings from lower courts, not necessarily hearing new evidence. So they get this little half-hour, you know, review of the findings of the lower case courts, and they're supposed to be comparing that with the law. And then in the course of doing that, if they say, you know what, is this law really a good law? Does it stack up to the Constitution? And there's where they get into the so-called constitutional interpretation role. It is really in evaluating the facts of the case against the law, and then the law against the Constitution. And that's really all I want. If any justice that sat down with the president or sat before a Senate panel and said, yeah, this is how I feel about abortion, and this is how I feel about gay marriage, and this is how I feel about whatever, you know, eminent domain, I think immediately disqualifies themselves. I don't give a rip what you think about those issues. What I want to know is, how do you examine the facts of a case? How do you compare that to the extant law? Do you consider, for example, that something that we call precedent is what I've heard actual Supreme Court justices refer to as settled law? There is no such thing as settled law. The law is always under evaluation as new cases come up, and they say, how does the facts of this case compare with the law and then the Constitution? I just want somebody who's going to look at that and evaluate each case on its merits. And I want to never know how a particular justice is going to vote on any issue. I want to see that they use common sense and the law itself and the Constitution in deciding cases. For Bill Whittle and Stephen Green, I'm Scott Ott. Thanks to the members at BillWhittle.com for making Right Angle possible.